How you guys doing today? It's Anthony Ganji. Welcome to another episode of Tear Talk. Guys, we got a heart-wrenching story. It's about Amerie Jones. If you guys are not familiar with this case, I'm still learning it right now. It is a very tragic incident. The mother actually posted pretty much in detail what happened to her daughter, even shared some pictures. The young girl is 5 years old. The details of what happened to this young girl is just tough to read. And what's even worse are the people that are accused of doing it. They're young kids, 10, 9, and 8. So we're going to go over a lot here. And if she's going to share the details, I'm going to share the details. I know some people are so afraid to say the details because they're going to get demonetized. This isn't about money. This is about sharing a story in the way the mother wants that story to be shared. It kind of reminds me of the Emmett Till case back in the mid-50s, 1950s. I think it was 1955. The mother was brave, had the open casket so the world could see what happened to her son, and I kind of see it here. And there is something of a concern that maybe we as a community can address. And I do have my notes here. We're going to read through it. We're going to learn through this together, take this journey together. I got a few videos I want to show you, a petition that they're working on signing, which will be one of the concerns I'm going to try my best to inform you a little bit more about. But let's get into this. So let's first give you an overview. I got this video on YouTube. It's right here. So let's play this first. So let me, and guys, bear with me, guys. I'm learning how to do all this. So, but let me, so we have a lot to discuss today. All right, here we go.
Mother wanting justice. She says her 5-year-old daughter was beaten, abused, and traumatized. I'm Katie Houston.
And I'm Damon Maloney. We first learned about this after receiving multiple phone calls and emails about a Facebook post detailing the violent attack.
News 5's Nadine Abusada sat down with that mother who wants everyone, Nadine, to know what happened to her daughter.
Katie, Damon, we want to warn those that are watching that what you're about to hear and see may be graphic and disturbing as a mother demands answers and justice for her daughter. She a mini you.
Yeah, she literally will crack you up. Like, she's so proper, the way she talks, everything about her is just like bubbly.
When talking about her 5-year-old daughter,
So
Antavia Kennebrew
bubbly.
lights up.
She is very, very affectionate.
But sadly, that joyful spirit
It was horrible.
is broken.
The bubbly 5-year-old. And I know she was not there no more.
We're not naming the child or showing her face because she is a minor. But this horrific story begins on September 13th. Antavia says she left her 5-year-old daughter at a family member's house. Then she got a call. Her daughter was missing. When she arrived, the little girl was already in an ambulance.
I could not recognize my daughter. Her hair was ripped out of her head. She had blood and bruises all over her. Her nails was filled in dirt, and she was unresponsive.
Antavia says her daughter was taken to a wooded area where a group of children attacked her. The allegations, which include sexual assault, are too disturbing to share with you.
That is so evil. It's so evil.
News 5 reached out to Cleveland police regarding this incident. What can you tell me about this investigation involving a 5-year-old allegedly being assaulted?
It is an active investigation that the Cleveland Division of Police is conducting at this time.
In a statement, the department confirmed that the Sex Crimes and Child Abuse Unit is actively investigating a case involving multiple children under the age of 10, both as victims and as suspects.
And we have to protect the rights that the victims have, just as well as the suspects in these cases.
Antavia says her daughter spent about a week in the hospital. The moment she opened her eyes,
She was screaming. When she woke up, she said they killed me. She thought she was dead.
the memories came flooding back.
To hear your baby say that she dead, what? A 5-year-old shouldn't even know that word. Like,
How is she now?
she's struggling mentally and behaviorally. She say things that she never said before, more violent, more suicidal things.
She says now Her focus is on just two things: making sure her daughter heals and getting justice.
You posted about it. Why? Why did you want to speak out regarding what happened to your daughter?
Because I needed justice for my daughter.
So when you say justice, what does that look like?
Everybody involved in the pain that was inflicted on my daughter, they get what they deserve.
As of now, no charges have been filed in this case, and Cleveland police reiterate that it is still under investigation. For Antavia, she has legal representation, and she plans to keep fighting until she gets justice. Damon, Katie, truly a heartbreaking story.
Nadine, disturbing to hear, and we know you'll continue to follow through as police continue to work through the case and try and get some answers for this family. Thank you very much.
So I wanted to show you guys her Facebook page. She is starting to gain some support. Let me make sure I have the Facebook page up. So bear with me. It is right here. Let me just make sure you guys can see it. Yep. So if you look here, she's already up to 25,000 followers. Now, this is the post that she put on that got all this attention. I actually took the details of what happened to her from this post. So we'll go through that later on, but it's a very long post. You guys can check out her Facebook page. And then this is the pictures of her daughter. Look at the hair, how it's pulled out. And wait till we go over the details. And this is her. Look how beautiful she is, this little girl. All right, let's get back. I want to show you guys one more video that's on her page, and then I want to show you this petition right here. It's signed the petition, change the Ohio juvenile justice loophole for young offenders. And I guess this is where I feel the impact can be created. And again, you see justice for Marie. There's pictures of her. But I want to show you this. So let me enlarge in this.
Cleveland police are investigating allegations a 5-year-old girl was sexually assaulted by other young children. Of course, this is a tough story to tell and a tough story to hear. Annabelle Childers spoke with police and the victim's mother today.
I want to get justice for my daughter. I want them to know how serious this is, the pain that she endured and how it changed our life forever. I want them to take it serious. I want everybody to look at it as if this was their kid.
On the afternoon of September 13th, Cleveland police officers responded to a home in the 1000 block of East 145th Street. A caller reported she was babysitting a 5-year-old girl, but the girl had gone missing. The police report is heavily redacted, but it states the 5-year-old was found in the fetal position in a field under a quarter-mile away from the residence. A witness told the responding officer that they saw 3 juveniles take the 5-year-old girl to the field and attack her. It's unclear who picked up the girl from the field, but she was transported to the hospital by EMS for emergency care. Investigators later found evidence and the girl's clothing in the field. And according to the police report, video evidence and ring camera footage were also recovered. The police report lists the offenses in this case as sexual battery, kidnapping, felonious assault, strangulation, assault, and rape. It does not state whether any witnesses intervened or attempted to stop the attack.
We're actively investigating it. Our detectives, working to resolve it. Unfortunately, like I mentioned, it is a very sensitive investigation at this point.
Cleveland police do confirm the victims and suspects in this investigation are under 10. Meanwhile, Antavia Kennebrew is still processing the pain that was inflicted on her daughter.
She been affected mentally and physically by what was done with her. So just seeing how much she changed is hard. What was done to her was inhumane. So it made me think like it wasn't no more human decency left. If you see anything and it doesn't look right to you, say something about it, because that could have stopped what happened to my daughter if somebody spoke up and say, if they stopped. So just speak up.
And right now, it is unclear what charges may be filed in this case. Cleveland police are still conducting their investigation before they turn over evidence to the prosecutor's office.
Well, I want to show you the petition that they want people to sign. They need about 50,000 signatures. Right now, I think it's over 5,200. Let me show you this petition. And the petition is going to address what part of our dialogue will be today. So this is basically just taking this journey together, learning where this gap is, because you never know what happens in Ohio could be relevant in other places as well. But right now, this is really for Marie, or some people even just call her just Marie, Marie. So change Ohio's juvenile justice loophole for young offenders. And they got about 5,300 signatures right now. So here's the issue. I'm a mother deeply committed to ensuring the safety, voice, and protection of all children. When I met Ontavia Kennebrew, the mother of 5-year-old Marie, my heart broke as she shared her devastating story. Despite the unimaginable harm that befell Marie, Ontavia was told that the 8 and 9-year-olds involved could not be charged due to their age. As a mom and community leader, I cannot stand idle by in the face of such injustice. In Ohio, our juvenile justice system is failing our children, both victims and those who need intervention at crucial stages of their development. That's key that she said that, because it's about accountability and rehabilitation for children, not so much about punishment. So it was great that she's talking in that type of language that should be understood by even advocates for the suspects, because what they did to this girl, and you'll see as I read through it, it's insane. So under current Ohio law, it's there, prosecutors are prohibited from transferring juvenile cases to adult courts unless the youth is at least 14 years old. As a result, most counties opt not to pursue delinquency cases against children younger than 12, leaving severe cases of physical assault, abuse, or cruelty in legal limbo where no one is held accountable. This legal loophole means that 8 and 9-year-olds can commit serious acts without any consequences or behavioral interventions, risking further harm to themselves and others. The system currently does not address or rehabilitate young offenders who may need guidance and support to prevent escalation to more serious offenses. So we're pushing more towards prevention. I propose to change Ohio juvenile justice law to fill this gap. We need legislation that allows for comprehensive investigations and appropriate interventions for children under 12 accused of violent acts. Such measures would ensure that all cases are treated with the seriousness they deserve while providing necessary support and rehabilitation for young kids. I call upon Ohio state lawmakers to act urgently and reevaluate our juvenile justice laws. We must protect our children and offer pathways towards rehabilitation rather than leaving them to slip through the cracks of our justice system. Again, I love the approach. It's about rehabilitation because, again, that should get everybody, both the victim side and the suspect side, to really take a look at this. Let us fight for the robust system that addresses these critical issues and ensure the safety and well-being of all Ohio's children. Please sign this petition to demand justice reform in Ohio for our youngest and most vulnerable residents. Together, we can make a difference. And this was put together, it looks, by Ebony Spano. And let me just see if I can. Okay, and that's the sign in. All right. Now, we do have a lot to discuss here. So let's do the timeline of events first, guys. And I'm learning it with you. Okay. For me, modernization doesn't matter. I'm going to just say what's in front of me. And when I share the details of her case, it's coming from the post that she posted. So it's going to be shared in very graphic detail. So then this is definitely for adults. And if this is not something you want to hear, I get it. You can always try to fast forward through it. But I think it's also good to understand what happened to her so you can understand the severity of the offense. And then also what can you do with children, especially the kids that are 8 and 9. That's the main concern here. Again, there's 3 kids, 10-year-old, a 9-year-old, and an 8-year-old. But the 9-year-old and the 8-year-old is where we may have concerns here. So September 13, 2025, the disappearance and assault. So Ontavia Kennebrew left her 5-year-old daughter, Marie, we'll call her Marie, in the care of a trusted family member near East 145th Street and St. Clair Avenue in Cleveland, Ohio, while Ontavia underwent a medical procedure. Sometime that day, Marie walked out of the house on her own and went missing. A witness later reported seeing 3 juvenile boys, all under age 10, taking a little girl into a wooded field in the 1000 block of East 148th Street. According to police reports, the 3 boys, believed to be age 8, 9, and 10, physically and sexually assaulted Amarie in the wooded area. They allegedly beat her until she was unconscious and left her naked and unresponsive in the field. So again, later that day, September 13, 2025, rescue and hospitalization. After discovering Amarie was missing, the family member frantically searched for her and alerted authorities. Initially, 2 of the young boys in the neighborhood denied knowing anything about the girl's whereabouts when asked by Amarie's caregiver. Subsequently, those same 2 boys returned with their mother and led the caregiver to the field where Amarie lay badly injured. The caregiver rushed the child from the field and met responding EMS units. When Ontavia Kennebrew arrived at the scene, she found her daughter in an ambulance, unrecognized from the injuries. Amarie was unresponsive, covered in blood and dirt, with her hair ripped out and bruises all over her body. Let me just show you these 2 pictures I got. Again, this is from the mother's Facebook page. Let me just remove this real quick. But look at this, guys. This alone. Look at the hair. And this is her beautiful little girl. And then look at this again. Look at the hair. This has got to break you. Paramedics transported the child to the hospital where she was admitted in critical condition. Now we're going to move. Okay, so it's during the recovery now, mid-September. Amarie remained hospitalized for about a week, receiving treatment for her severe injuries. When she finally regained consciousness, she was disoriented and terrified. Her mother recalls that upon waking, Amarie screamed, "They killed me," believing she had died. This heartbreaking statement underscored the trauma and confusion the 5-year-old experienced as she began to recall the attack. Now we go to late September of 2025. You have the ongoing investigation. Cleveland Police Sex Crimes and Child Abuse Unit launched an investigation on September 13th and continued to actively investigate through the following weeks. Detectives gathered evidence from the scene and the hospital and took statements from witnesses. It was confirmed that multiple children under the age of 10 were involved as suspected perpetrators and possibly as additional victims. That's interesting. So because all involved are minors, police released a few details publicly in September, citing the need to preserve the investigation's integrity and protect the privacy of the children. Early October 2025, you have public disclosure and media report. After a few weeks with no public update from authorities and concerned that justice was not being swiftly served, Ontavia Kennebrew decided to share her story publicly, and that's the pictures you saw on Facebook, and with her message. In early October, she wrote a detailed post on social media describing the attack and her frustrations. This post later formed the basis of a GoFundMe campaign titled "Justice for Amarie." Local media outlets quickly picked up the story. October 5th through the 8th, 2025, Cleveland news station ran graphic but factual reports of the incident, interviewing Ontavia and confirming that police were investigating a child-on-child assault. Ontavia described her daughter's condition in those interviews, saying, "I literally saw the worst thing ever. My daughter was unrecognizable," and recounting the horrific state in which she found Amarie. October 7th, there's a police statement. In response to growing public attention, the Cleveland Division of Police issued an official statement, and this was through social media, acknowledging the circulating story. The police confirmed an ongoing investigation into a matter involving multiple children under the age of 10, both as victims and as suspects, but stressed that no further details could be released due to the sensitive nature of this case and to avoid compromising the privacy and constitutional rights of those involved. This was the first formal confirmation from authorities of the basic facts, the ages involved, and that it was being handled by the Sex Crime Child Abuse Unit. So October 7th, when we found out that the age of the individuals is a concern and that it has been picked up by the Sex Crimes Child Abuse Unit. So on October 10th, that's the most recent report we got, you start seeing the community giving support, and you can see it through Facebook. She's already got over 25,000 followers. Outrage and sympathy in the community continue to build. On Friday, October 10th, local residents and supporters organized a community united toy and gift drive for Amarie at the Zelma Watson, Georgia Recreation Center. Dozens of people gathered to donate toys, cards, and messages of support for the little girl and her family. Ontavia, who attended the event, was moved to tears by the outpouring of love. She said, "Every person that comes up to me is making me break down. She said, humbled by how many strangers showed care for her daughter. This show of community solidarity reassured her that she was far from alone in seeking justice. Mid-October, again, just final thought here. Current status is as of the second week of October 2025, the investigation remains active and ongoing. No charges have yet been filed against any suspect. Amarie is now at home recovering with her family and is undergoing therapy to cope with the psychological trauma. Ontavia Kennebrew has obtained legal representation and continues to advocate for action, vowing to keep fighting until she gets justice for her daughter. The case remains in the public's eye due to continuing social media engagement and media coverage. All right, let's go to the confirmed facts and official statements. Despite the sensitive nature of the case, several core facts have been confirmed by authorities or reliable sources. So now we're going to talk about age, the nature of the allegation, the charges. Guys, so we're going to talk about details here. And again, I'm getting it from the mother's social media page. So just have no young kids around. This is very graphic what they did to this young little girl. So Cleveland police confirm that on September 13, 2025, a 5-year-old girl was reported missing from a home on the city's east side and was later found assaulted in a wooded area on East 148th Street. The victim had severe injuries consistent with the physical and sexual assault. She was transported to the hospital by EMS, but she did survive the attack. Suspect's identity. Here's the ages and status. According to the Cleveland Division of Police, the alleged perpetrators are children themselves, all under the age of 10. The initial police report documented that a witness saw 3 juveniles taking the girl into the wooded area and assaulting her. Who's that witness? And Ontavia Kennebrew has stated, and police have not disputed, that the boys are approximately 8, 9, and 10 years old. The children were reportedly neighborhood kids, unrelated to the victim, who lived on the same street as the family member's home where Amarie was staying. No names or identifying information about the boys have been released publicly due to their ages and legal protection for minors. And that's going to come into effect as we move through this. This is what we're going to learn together. It's a journey we're all taking right now. Police investigation. The Cleveland Police Sex Crimes and Child Abuse Unit is handling the case. Investigators have collected evidence, statements from witnesses, medical forensic evidence from the child's examination, etc., and are working with Cuyahoga County juvenile authorities. Police officials have repeatedly described it as an active investigation. They have declined to discuss specific evidence or allegations in detail, citing the need to protect the case's integrity. In an official statement, Sergeant Freddie Diaz of Cleveland PD emphasized that the rights of both the victim and the young suspects must be protected during this process. And guys, by the way, even though the mother put the brutal details out there, hopefully that doesn't mess with the investigation. She felt she needed to do it because she felt that she wasn't being heard. And she thought this could be very relevant to probably the ages of the suspects. So while police have not publicly itemized the allegations, they have acknowledged the broad outline of the crime, that the 5-year-old was physically and sexually assaulted by multiple children. The initial incident report corroborates that various assaults occurred. So News 5, Cleveland, after obtaining the police report, noted that the written details support Kennebrew's claim that her daughter was viciously attacked, even though the exact specifics were deemed too graphic to broadcast. Authorities also confirmed that multiple children under the age of 10 are involved both as victims and suspects in this matter. This phrasing suggests that one or more of the juvenile suspect could possibly have been victimized in some way as well, or it may simply refer to the primary victim and the young age of the offenders. That's what I was thinking, the latter, but you never know. No charges filed yet. It's officially confirmed that as of mid-October 2025, and mind you, this happened September 13th, no arrest or charges have been announced. So you can see why the mother was trying to push it, because obviously 15 days around October when she first started saying, hey, are they going to do anything? And nothing was happening. She didn't see any charges. She went and took measures into her own hands, put it out there for social media for support. So it's officially confirmed that as of mid-October 2025, no arrest or charges have been announced in connection with the case. This does not mean the crime isn't being taken seriously. Rather, it reflects the unusual situation of having very young alleged offenders. That's what we're going to guide through today, this journey. Law enforcement proceeding cautiously, likely consulting with juvenile prosecutors and child welfare officials as how best to handle it. The public statement from police indicated that releasing additional information at this time could jeopardize the integrity of the investigation, implying they are still gathering facts and determining next steps behind the scenes. Now, there was official acknowledgement of the social media post. The Cleveland Division of Police specifically referenced being aware of a post recently shared regarding an ongoing case in their public statement. This was an indirect acknowledgement of Ontavia Kennebru's viral Facebook post detailing her daughter's assault. The police assured the public that the matter was under active investigation, likely aiming to quell rumors and assure people that the case had not been ignored. However, they also cautioned that no further details could be shared due to privacy concerns and the constitutional right of the juveniles involved. By the way, if you look at her post here, it has 61,300 likes. That's more like acknowledgements, what I meant by likes, engagement. And then 132,000 shares and 17,000 comments. That's a good amount. So that's definitely going to put some pressure where it needs to be placed. So the Cleveland city officials' response, there's not yet been a detailed public comment from the mayor's office or city officials regarding this case. That's as of today, October 11th. Mayor, where am I? Ontavia Kennebru has reached out to the Cleveland mayor's office seeking help, but as of the latest report, she has not received a response. The lack of immediate public comment from officials may be due in part to the fact that the suspects are minors, making it a closed juvenile matter, and possibly to avoid prejudicing any legal proceedings. The case is nonetheless on their radar due to the public outcry, even if formal statements are limited. So in summary, authorities have confirmed the basic elements of this shocking incident: a 5-year-old girl brutally assaulted by a group of very young boys, and have stressed that that's being investigated with care. However, the specifics of what happened have largely come from the family side, as police are tightly controlling information for legal reasons. No one has been charged yet, which leads to significant public concern and scrutiny addressed in later, which we'll address in later sections. Okay, so this is the allegations that were made by the family and caregivers. Okay, so this is what I got from that post. This is where it's graphic. So the family account of what happened to A. is extremely disturbing. Ontavia Kennebru has publicly alleged the following sequence of events and details based on what she was told and what evidence was observed. So guys, bear with me on this. I'm going to read exactly what happened as noted in the mom's, Ontavia's Facebook page or her profile page. So the 3 boys, approximately 8, 9, and 10 years old, encountered Amarie after she walked out of the house. They presented themselves as friendly to the little girl, took her by the hand, and lured her away to a nearby secluded field down the street. This implies a level of premeditation and manipulation even at their young ages. They had to convince a 5-year-old to leave with them. The field was a wooded, overgrown area out of sight of nearby homes. A neighbor described that end of East 148th Street as quiet and partially empty, which may be why no adult immediately saw the attack. Once in the wooded area, the boys attacked Amarie with shocking violence. According to Kennebru's written statement, the children beat her daughter until she was unconscious. They allegedly ripped her hair out of her scalp, which you saw here. They also hit and kicked her severely. There were signs of strangulation on her neck, indicating they strangled or attempted to strangle her, including apparently using her own T-shirt to choke her at one point. Ontavia recounted that her daughter's lips and mouth were bloodied and her eyes had hemorrhaging, suggesting head trauma and possible asphyxiation during the assault. A large lump was noted on her child's head, possibly from a blow to the skull. And then there's the sexual assault and degradation. The family alleges that the attack included heinous sexual abuse of the 5-year-old. Kennebru says the boys held Amarie down and raped her. Some of the graphic details from her account include claims that the assailant shoved sticks or other objects down her throat and into her private parts, causing internal injuries and leaving debris, which is dirt and twigs, in her vaginal area and throat. The boys reportedly stripped her naked during the assault. In a particularly degrading act, one of the boys is said to have urinated on her after exposing himself. They also allegedly bit her. One boy ingratiated their teeth on her bottom area to hold her still in the mother's words. All this is coming from that post, which suggests she sustained human bite marks on her body. These acts go far beyond a simple childish misbehavior. The allegation describes a prolonged torture of the child. And then there's the attempted murder. Tavia firmly believes the intent was to kill Amarie. The level of violence, strangulation, beating until unconscious, penetrating injuries could easily have been fatal. Again, guys, this reminds me of just the Emmett Till, the bravery of the mother to showcase to the world that they need justice. The fact that the boys left her motionless body in the field and did not seek help supports this view. Kennebrew wrote that the attackers, after assaulting her daughter, left her where she was, not telling any adult, thinking they succeeded in killing her, and then continued playing as if nothing happened. In essence, they abandoned the 5-year-old to die. Amarie herself later told her mother in an innocent but haunting way that she thought she was dead during the attack. The family characterized the incident as an attempted murder of the child in addition to sexual assault. Now, after the assault, 2 of the perpetrators, boys, the 8 and the 9-year-old, were encountered by the frantic family member who was searching for Amarie. Kennebrew says her relative, often described as a cousin who was babysitting, asked these boys if they had seen a little girl. They stared with no remorse and lied, saying they hadn't, and then continued to play. At that moment, the family member did not realize those were the attackers. Only later, when the boy's mother found out and forced her sons to come forward, did they lead the family to the field where Amarie lay. Ontavia credits that other mother's intervention with saving her daughter's life. If those kids' mother did not make them go back and let my family member know where my daughter was at, my baby wouldn't be found right now. My baby wouldn't be alive. This implies that at least one of the perpetrators confessed to his mother about what they had done, prompting her to do the right thing and alert the victims' families. It also indicates that the children initially showed no guilt or intention of revealing the crime until an adult compelled them. So when Amarie was found in the field, she was naked, unconscious, and badly beaten. Her clothing, shoes, and even clumps of her hair were scattered around the crime scene, evidence of the struggle. The family members who retrieved her was reportedly in a panic, but got her to safety as quickly as possible. In Ontavia's first glimpse of her daughter in the ambulance, she could barely recognize her. Her hair was ripped out, blood and bruises all over, nails filled with dirt, unresponsive. This harrowing description has been consistent across Ontavia's statements to media. It paints a picture of just how savage the attack was, given that a small child's appearance was altered so drastically. In addition to describing the assault, Ontavia Kennebrew has made pointed allegations that the legal system was initially failing her daughter. She says that after weeks went by, investigators informed her that 2 of the boys, the 8 and 9-year-olds, can't and won't be charged due to their young age. This news was devastating to her, as it suggested that the majority of the perpetrators might face no legal consequences at all. They literally tried to kill my daughter, and they're saying legally these 2 boys cannot be charged, she wrote, expressing disbelief and anger. Ontavia also felt that the case was not getting enough urgent attention from authorities. This perception is what pushed her to go public with the story. She has said, the authorities are failing my daughter, claiming that she initially trusted that Amarie was going to get the justice she needed, but saw little progress. Only after media coverage and public pressure did she start to sense it was being taken seriously by officials. Now, the family demands that everybody involved in the pain inflicted on Amarie get what they deserve. Ontavia has openly stated that these are not normal kids and that the parents of these children also need to be held accountable in some fashion. She's implying negligence or poor supervision by the perpetrators' guardians, given the extreme violence that occurred. At this stage, these are allegations and pleas. No perpetrator, parent have been officially accused of a crime. However, Ontavia's sentiment resonates with many in the public who feel someone must answer for what happened, even if the direct offenders are below the age of criminal culpability. It's important to note that the above details came from the family side of the story, primarily Ontavia Kennebrew's posts and interviews. They have not all been independently confirmed by police, likely because the police cannot publicly confirm them without jeopardizing juvenile privacy. However, many elements of her accounts are supported by evidence referenced in police reports and hospital records. For instance, the severe injuries were documented by medical staff and observed by reporters, and a witness did see 3 children assaulting the girl. The broad consistency between what the mother alleges and what journalists have verified in general terms lends credibility to her account. Still, the full truth will ideally be established by the official investigation, which is ongoing. I'm wondering, because I'm thinking if someone witnessed it, why didn't they act? Unless they were a juvenile themselves and they were also a victim at some level, and then basically was kind of pushed aside why they did this to the other young girl. So maybe the witness is also a victim, and maybe the boys had targeted two girls, or a girl and a boy. I don't know at that point, but basically maybe the witness is another young kid who was also probably going to be maybe assaulted, because that kind of runs parallel with the statement above that there could have been more than one victim. And again, we're taking the journey together. Or when they said victim, it could have just meant her. But then my thought is, well, why didn't this person act? And I'm thinking of it being an adult. I would act immediately. But maybe this wasn't an adult. Maybe the other witness is actually another victim. Ontavia's allegation go beyond just telling what happened. They include a critique of the system's response. She has actively sought help, reaching out to legal aid, the Cleveland Metropolitan Bar Association, and the Rape Crisis Center for a Victim Advocate. She even contacted the mayor's office asking for intervention. As of her latest statement, these efforts had not yielded tangible assistance, heightening her frustration. This advocacy by the family underscores that they feel justice for Amarie is not assured unless the public and higher-ups get involved. In summary, the family's narrative describes a horrific crime committed by children and expresses deep concern that because of the perpetrator's ages, the normal path to justice are inadequate. These allegations have been the driving force behind the public outcry and the Justice for Amarie campaign. Now we're going to talk about the legal status and the case. All right, so this gets to be where we're going to have to start putting our heads together. So, again, we're all on this journey together. We're learning, and then I'll try to get some of my guests on again, like maybe Denise. So, as of the latest information, mid-October 2025, the legal status of the Amarie case is a complicated preliminary state. So the investigation phase, the case remains firmly in the investigative phase. Cleveland police have an active open investigation and are working closely with prosecutors in the juvenile division to determine how to proceed. All evidence, including forensic evidence from the scene and hospital, witness statements, and interviews with the children involved, is being carefully reviewed. Because suspects are minors, investigators likely have involved child psychologists or social workers in any interviewing process to ensure it's done appropriately. And the police have not closed the case. It's an ongoing and being actively investigated by the Sex Crimes and Child Abuse Unit. But remember now, we have no criminal charges filed. So no one has been formally charged or arrested at this time. So this point cannot be overstated. The usual immediate outcome in a brutal crime, an arrest, has not occurred here because of the unique issue of the suspect's ages. Under normal circumstances, if such an assault were committed by adults or even teenagers, charges like attempted murder, rape, kidnapping, and assault would likely be filed swiftly. In this case, however, the suspected offenders are children below the typical age of criminal responsibility, which gives law enforcement pause. Police have confirmed that as of now, no charges have been filed in this case, and they're carefully navigating the situation. Now, this is where juvenile justice involvement. Although no charges are filed, this matter is under the purview of juvenile justice authorities. It's possible that the 10-year-old suspect could be subject to a juvenile delinquency petition, even if the 8 and 9-year-olds are not. This is discussed more later. If such a petition is filed, it would happen in Cuyahoga County Juvenile Court and would not be public information due to confidentiality rules. As of the latest reports, there's no public record of any juvenile court filings, which is expected since juvenile records are sealed and the authorities have not announced any specific legal action. Now, with custody of the suspects, the current status of the three boys, what's being done with them, is not officially disclosed. Given no formal charges, they likely have not been detained in a juvenile facility, particularly the 8 and 9-year-old. They're too young for secure detention in Ohio for most cases. And they are presumably in the custody of their parent guardians. However, one can reasonably assume that Cleveland child welfare agencies, Children and Family Services, might be involved by now. In cases where children commit violent acts, even if they are not charged with a crime, authorities might evaluate the home environment. If the household is deemed unsafe or the children have serious behavioral issues, social services could initiate proceedings like declaring them dependent minors in need of intervention. No specific information on that has been released, but it's an avenue the system could be pursuing quietly. And the victim legal representation, Ontavia Kennebrew has secured legal representation for herself and her daughter's interest. She indicated she contacted legal aid in the Bar Association. It appears she now has an attorney or advisor assisting. This is important because the family may need to navigate the juvenile justice system, which can be opaque to victims or even consider civil action. The attorney can also help in communicating with prosecutors and ensuring the victim's rights are respected. Ohio does have a victim bill of rights known as Marcy's Law, which could apply here to keep the mother informed. So Marcy's Law is a victim right law that has been adopted in many U.S. states. It is named after Marcy Nicholas, a college student from California who was murdered in 1983. After her death, Marcy's family ran into her accused killer in a grocery store because they weren't told he had been released on bail. That experience drove her brother, Henry Nicholas, to push for stronger constitutional rights for crime victims. Let's read that again. Hold on. After her death, Marcy's family ran into her accused killer. Okay. Marcy's Law is a constitutional amendment passed state by state that gives crime victims rights similar to those given to defendants. Depending on the state, these rights usually include right to be informed. I'm very familiar with this, about court proceedings, plea bargains, and the release of the accused, right to be present at hearings and trials, right to be heard at critical stages such as sentencing, parole hearing, or bail hearings, right to safety and privacy, including protection from harassment or intimidation, and right to restitution from the offender when possible. While supporters say Marcy's Law balances the justice system by giving victims a stronger voice, critics argue it sometimes conflicts with defendants' rights. I mean, the defendants care about their rights. Strain resources on courts and prosecutors. It shouldn't even matter. Yeah, this is the victims should always take priority. It's too vague or overly broad, leave an interpretation up to judges. So you'll give the resources to the defendant, but you won't give any to the victim. So again, it was first passed in California in 2008, I got. Since then, states like Florida, Ohio, Kentucky, Nevada, Oklahoma, Wisconsin, North Carolina, and others have adopted it in some form, and not all states have passed it, and its application can differ widely. Why would you not want to pass that law? So official classification, it's worth noting that authorities are classifying this incident legally. They're investigating serious felony level offenses if committed by an adult, rape, kidnapping, felonious assault, attempted homicide, but because suspects are children, these are being handled as a potential delinquency case rather than a criminal case. The distinction, if charges proceed, it would be in child's name, in juvenile court for delinquency, equivalent to saying the child violated criminal law without calling it a conviction. The public might not hear terms like rape or attempted murder used by officials, but the behavior is being treated with that level of severity behind the scenes. Kennebrew has voiced that she felt left in the dark initially, but after media attention, it appears authorities have been more communicative. She said now everybody knows that they're being watched closely, referring to how the public scrutiny has perhaps prompted more responsiveness. The police will have limitations on what they can share with her. For example, they probably cannot divulge everything the kids told them, but they likely informed her of the key points that two suspects cannot be charged, which they did. They might also have explained they are evaluating what to do with the 10-year-old suspect. And to clarify, this case is not going to an adult criminal court, given the ages, so there'll be no grand jury indictment or adult trial. The usual felony process, charges in municipal court, bind over, etc., is not applicable here. Instead, any formal action would occur in juvenile court, which does not involve juries or public proceedings in Ohio for such young respondents. While two of the boys are below chargeable age, the oldest boy, 10, may still face juvenile charges. It has not been publicly confirmed if he has or will be charged, but behind closed doors, prosecutors might be weighing a delinquency charge for rape and assault at minimum. The challenge is proving which boy did what, especially if they're all blaming each other or staying silent. The presence of DNA or physical evidence like the bite marks or forensic evidence from the rape kit could be crucial in tying acts to a specific child. This process can take time, especially with juveniles, because they may need to be psychologically evaluated. This process can take time, especially with juveniles, because there may need to be psychological evaluations of the offenders before proceeding. And most likely each family may even get if they need lawyers, they may each get their own child a different lawyer. And now it's just going to be everybody pointing the finger. So hopefully the DNA test, whatever the forensics are, come back and really show you specifically, or can tell the story specifically what happened to this girl by who did it. And then it looks like there's a witness on scene. If the witness could have been another victim that at the moment was pushed aside, then maybe she could also be more detailed. This way we can make sure, direct responsibility goes to the main person who was doing what was wrong. I want all three to be held accountable, but the last thing I want is for the main person who done the most to be his accountability to be minimized, because everybody's blaming each other. So in summary, legally, the case is in holding pattern. It's been actively investigated and taken seriously by law enforcement, but the normal progress to charges is stalled by the suspect's young ages. The family's push for justice is essentially a push to find some way to hold the perpetrators accountable, despite these age-related obstacles. The next official development might be either a quiet filing in juvenile court for the 10-year-old or some public statement once the investigation concludes. Until then, the case is unresolved in a legal sense, a deeply troubling alleged crime with no one yet formally charged. Now, I want to go to the medical and forensic details. So, again, guys, there's a lot here, so bear with me. Let's get to the medical and forensic details. Where is that? Bear with me, guys. I got to find it. It's right here. It's the next part. Hold on. Let me see. Is it right? Bear with me, guys. I'm going through my notes right here. So medical reports and forensic evidence. From this case, Medical reports and forensic evidence from this case paint a horrifying picture of the abuse Amerie suffered. Many of the details have been shared by the family and corroborated by hospital evaluations. So physical injuries, Amerie injuries were extensive. She had significant head trauma, described by her mother as her hair being scalped from her head, meaning chunks of her hair were torn out, likely along with pieces of scalp skin. She had a large hematoma, bump on her head, indicating a hard blow or impact. Her eyes were filled with blood, subconjunctival hemorrhages. Excuse me, guys, because my wording sometimes. And her face was bruised and swollen. This could result from strangulation or blunt trauma. Her lips and mouth were bleeding and cut, possibly from being struck or from having something forced into her mouth. Bruises and abrasions covered her body from head to toe. The mother noted every part of her was hurt. Bruises and blood all over her body. These are consistent with a prolonged beating and struggle. And then you got the strangulation evidence. Medical personnel observed ligature marks or bruising on Amerie's neck, consistent with strangulation attempts. The mother specifically mentioned her neck showing signs of strangulation. Strangulation in children can cause tiny red spots from burst capillaries, and that's the pediatric. That word gets to me too. And that's on her face, which might explain the blood in her eyes. It's a serious red flag because even brief strangulation can cause brain damage or death in a child. And then you got the sexual assault forensics. Amerie underwent a sexual assault forensic exam, rape kit at the hospital, given the allegations of rape. While those results are confidential, observable evidence supported that a sexual assault occurred. Ontavia reported that her daughter's private areas were filled with debris and dirt, when she was found, strongly suggesting foreign objects and outdoor material have been introduced, which align with the claim that sticks were used to violate her. There were likely have been lacerations or trauma noted in the general area by doctors. The details that one boy urinated on her means her body or clothing may have had urine traces. This could be confirmed by forensic testing of her clothing. If any clothing was on her, she was found naked, but perhaps her shirt used to strangle her might have had bodily fluid. The hospital would have collected the child's clothing, swabs from her body, and any foreign material for analysis. If DNA from any assailant's saliva or skin was present, for instance, from the bite mark or touch DNA under her nails, that could be evidence, although collecting DNA from young children might be tricky without parental consent. The perpetrator's parents would need to allow a swab unless a court order is obtained. I'll be interested to see if the mother at least one of the mothers who brought the child back to the family do the right thing, will she continue to do the right thing? Bite mark. All right, so we got one unique forensic detail is the alleged bite mark on her buttocks from a perpetrator biting her to hold her down. Bite mark analysis can sometimes identify a suspect if the dental impressions are compared, but given the suspects are children with developing teeth, a forensic odontologist would have to assess if it's usable evidence. Nonetheless, it documents another form of sexual abuse. Forced biting is sometimes seen in assaults. And the dirt under the nails. Hospital staff noted that Amarie's fingernails were filled with dirt. This could mean she was clawing at the ground or at her attackers during the assault, a sign of struggle. Forensically, material under a victim's nails can sometimes contain skin cells of the assailant if she scratched them. It's unknown if that's the case here, but the dirt certainly corroborates that the assault took place outside on the ground and that she was in contact with soil, again, aligning with being dragged in a field. Unconsciousness and recovery. By the time she was found, Amarie was unconscious and remained unresponsive for some time. She required intensive medical care at the hospital. So according to her mother, she spent roughly a week in the hospital recovering. During that period, the medical focus would have been on treating her physical injuries, managing any head injury, concussion or worse, treating cuts, bruises, given prophylactic medication for sexual assault, such as antibiotics and maybe HIV prevention, which is standard after rape, and performing any needed surgery. For example, if there was internal damage from the stick, she might have needed a procedure. Could you imagine what she had to go through as a 5-year-old? Hasn't been publicly reported if she needed surgery, but given the mention of objects forced down her throat, there could have been throat or intestinal injuries. Well, they had to be checked. Her stable release after a week suggests she did not have life-threatening internal injuries, or if she did, they were managed. And then you got the psychological trauma. Beyond the physical wounds, the psychological and emotional trauma is severe. Immediately upon regaining consciousness, Amarie's first words, "They killed me," indicate extreme terror and a near-death experience perception. In the weeks following her mother reports behavioral changes. The child has become violent in play or speech, expresses fear and suicidal ideation, and is not her bubbly self anymore. She's a 5-year-old exhibiting PTSD-like symptoms, nightmares, mood swings, fear, and possibly regression in some behaviors. This is a medical concern as well. Trauma counseling is absolutely needed. She is now in therapy, which was arranged soon after the hospital stay. The mother, too, is seeking mental health support given the trauma of witnessing her child in that state. Forensic investigation of scene. The crime scene, the wooded field, was also subject to forensic investigation by police. It was described that Amarie's clothes, shoes, and hair were found scattered around. Investigators likely collected those items. If the boys used any tools or if there were any belongings left, for instance, if a stick with blood was found or any toy weapon that they might have had, that would be evidence. Photographs would have been taken at the scene, including the disturbed grounds, any blood stains, and the surrounding area. Given the public reporting, the scene corroborated the violence. It wasn't a neat or accidental situation. It was clear evidence of an assault. And then the medical examination of the suspects, although not confirmed, it's standard in such cases to also examine the suspected minors with parental consent or court order for any evidence. For example, checking if any of the boys had scratches or injuries from Amarie defending herself, collecting their clothing to see if they had blood or DNA from the victims, etc. Since all are under 10, this would have been handled delicately. We don't have public info on this, but it's a logical part of the forensic process. Wondering how that went. We'll find out more as the case opens up. All told, the medical and forensic evidence strongly supports that Amarie was the victim of prolonged violent sexual assault. The presence of physical trauma and forensic clues like debris and hair at the scene provide a compelling narrative consistent with what she later told her mother. These details are crucial for the investigation. Not only do they substantiate that a crime occurred, which is not in doubt, but they may help assign responsibility to the specific culprits, especially important if one of the three can be charged. The gravity of the injuries also influences the legal perspectives. This is clearly not a minor incident or playground fight. It's a near lethal level assault. From a medical standpoint, Amarie's road to recovery will be long. Physical wounds will heal. Many already have by now. A month later, though, she may have scars on her scalp or body. The greater challenge is psychological healing, given her age and the brutality she endured. The community toy drive and therapy are part of addressing these needs, but long-term support will likely be required. Now we're going to talk a little bit more deep about the legal limitations due to the suspect's age. This is, again, part of the journey of us trying to figure this out together, maybe where we can play a role besides signing the petition. So now one of the most challenging aspects of this case is that the suspects are extremely young, under 10 years old. We mentioned that. This raises significant legal limitations on how or even if they can be prosecuted or punished. Here are the key points regarding age and the legal system. And this is going to be what relates to the petition, where they need our help, So age of criminal responsibility. In Ohio, there is no hard and fast minimum age set by statute for when a child can be charged with an offense. In theory, a very young child could be subject to juvenile court jurisdictions. However, in practice and policy, children under 12 are rarely prosecuted, and it is virtually unheard of to prosecute a child as young as 8 or 9. So the rationale is that young children do not have the capacity to fully understand wrongdoing or participate in their defense. Indeed, Tavia Kennebrew was explicitly told by authorities that because 2 of the boys are 8 and 9, legally these 2 boys cannot be charged for what they did. This suggests that local officials are treating 10 as effectively the minimum age for delinquency in this scenario, meaning the 8 and 9-year-old will face no criminal charges. The 10-year-old falls just at that common cutoff and could potentially be charged in juvenile court. Now let's talk about juvenile court versus adult. All suspects are well below Ohio's threshold for even considering adult prosecution. Ohio law allows very serious juvenile cases to be transferred to adult court, but only for older teens, generally 14 or above, and for the most egregious crimes. There is zero possibility of transfer in a case involving 8 to 10-year-olds. Therefore, the only legal venue here is juvenile court, and even that is only applicable if prosecutors decide to proceed with the 10-year-old. Juvenile courts focuses more on rehabilitation than punishment, as we mentioned earlier, and it operates under different rules. For example, no jury trials and records are confidential. So for any case to go forward, even in juvenile court, the child must be deemed competent to understand the proceedings and assist in their defense. Assist in their defense. So children under 10 would almost certainly be found incompetent simply due to developmental stages. Even at 10, a competency evaluation would be likely. Many 10-year-olds might not grasp the abstract concepts of trial, rights, etc. If a child is found not competent, the court cannot adjudicate them delinquent. Instead, the system might order some treatment or simply dismiss the proceedings. This is a significant hurdle. Thus, even charging the 10-year-old may result in a finding that he cannot be put through a trial due to his age and maturity level. And then protection for juvenile suspects. The legal system affords strong privacy protections for minors. As seen in the police statements, authorities are careful not to release identifying information about the child's suspects. Court hearings involving juveniles, especially those under 14, are typically closed to the public, and records are sealed or highly restricted. This means if any boy is charged, the process and outcome may remain confidential, which can be frustrating to the public, but is intended to allow the child a chance of rehabilitation without lifelong stigma. Police also highlighted constitutional rights of those involved, meaning these kids have due process rights just like anyone, including the right not to self-incriminate. Any interrogation of them must have parental guardian consent and presence, and they might not even fully comprehend their rights. Very complicated. Inability to detain or punish young children. In Ohio, children under 10 cannot be held in juvenile detention facilities in most circumstances. Even for older juveniles, there are limitations. For example, under age 12, secure detention is rare. A 10-year-old, if charged, could potentially be held in a juvenile facility pre-trial, but it'll be very unusual and likely short-term. More likely, that child will be released to parental custody with perhaps some monitoring while the case is processed. If ultimately found responsible, so adjudicated delinquent, the disposition for a 10-year-old might include probation, mandatory counseling, perhaps placement in a specialized youth program or a juvenile rehabilitation center. They would not be sent to any form of adult jail or prison. And because of their age, even juvenile placement might be in a group home or treatment center rather than a lockup. By law, Department of Youth Services, Ohio's Juvenile Corrections Agency, cannot accept kids under a certain age, generally under 10. So in most cases, and there have been recent pushes to raise the minimum age for any juvenile incarceration to 12 or 14. The trend is towards treating kids under 12 with therapeutic intervention, not incarceration. And I see that a lot elsewhere, not just in Ohio. The liability of parents or guardians. Because the children themselves largely cannot be legally accountable in the criminal sense, one might wonder if the parents of the offending minors face any legal jeopardy. In general, there is no criminal charges for parents of a child who committed a crime unless there's evidence of parental involvement or negligence rising to a criminal level. If, for instance, the parents knowingly left dangerous instruments or facilitated the situation, they could conceivably force child endangering charges, but nothing in this case suggests the parents were directly involved in this assault. Ohio law does allow holding parents financially responsible for their children's actions in civil court for damages, but criminally, it's unlikely. However, the parents of the boys might become involved with child protective services if their kids did this. It raises concerns about what environment they're in. Where did they learn this type of behavior? Authorities might investigate if those children have been abused or exposed to sexual content or extreme violence, which could lead to the parents being mandated to get them help or even losing custody if they're found unfit. Those proceedings would be separate from the criminal investigation of the assault itself. And I was thinking that, by the way. Possible outcomes for the 10-year-old. It seems like the focus is going to be the 10-year-old. If the oldest boy, age 10, is charged in juvenile court and adjudicated responsible for, say, a rape or felonious assault, the juvenile court has flexibility in disposition. He could be placed on probation with intensive counseling, required to attend a juvenile treatment facility. There are specialized programs for juvenile sex offenders, for example, or in extreme cases, placed in custody of the state juvenile system until he's older. Typically, the maximum a juvenile can be held, even for serious crimes, is until age 21 in Ohio. So even in a worst case scenario for him legally, he might face around 10 or 11 years in a juvenile rehabilitation facility. More likely, given his young age, the system would favor rehabilitation over long-term detention, perhaps a few years in a youth treatment center, plus long-term probation and monitoring. Again, this is speculative since no charge is confirmed yet, but it outlines the bounds of what's legally possible. And as again, for the 8 and 9-year-olds, no formal consequences. For the 2 younger boys, 8 and 9, if they indeed cannot be formally charged, the focus shifts to intervention rather than punishment. The police or prosecutors might refer them to children's services for unruly child or child in need of supervision processes. This could mean mandatory counseling, psychiatric evaluation, and possibly the family being monitored by social workers. They might be placed in specialized programs for children with violent or sexual behavior issues. Some exist for preteens. And school authorities might also be looped in for safety planning, ensuring these kids are supervised at school and get counseling. But crucially, they will not have a juvenile court record if they're not charged. This is what outrages the mother and public, that 2 of the perpetrators might effectively face no judicial accountability for raping and nearly killing a child simply because of a few years difference in age. And then the privacy and sealing of case. If any juvenile case proceeds, it will be sealed in private. The victim's family will have some rights to be informed and heard. That's the Marcy law. It ensures victims can speak at proceedings like dispositions. But they won't be allowed to publicly divulge minors' identities. The media will likely never get official names or images of the offenders. Even after any proceedings, juvenile records are usually sealed and can even be expunged when the child reaches adulthood, particularly if they complete rehabilitation. This means that from a public perspective, the outcome might remain opaque. Unless the family chooses to share what they've learned, or unless someone leaks information, the community may not know if the boys were sent to treatment, put on probation, or simply left off with nothing. This confidentiality is well-intentioned to allow the children to reform without lifelong notoriety, but in a case this severe, it can feel like a lack of transparency or justice to the public. In summary, the suspect's young age creates a situation where the conventional justice system tools are limited. Essentially, the law views children under 10 as incapable of criminal intent in any meaningful way, and thus it does not readily apply criminal penalties to them. This case is exposing that limitations, even an act as awful as this, has no straightforward legal remedy if committed by very young minors. The only potential legal action is against the 10-year-old, and even that will occur in a juvenile framework emphasizing rehabilitation and privacy. This does not satisfy many observers' sense of justice, but it is the reality of our legal system designed to protect children, even those who do grave harm. Now, I want to go back to the public and media response, Justice for Amerie's campaign. So the public and media response to Amerie's case has been intense and evolving. So you have the initial social media outcry. The story truly gained traction when Ontavia Kennebrew took to Facebook with a detailed account of her daughter's assault in early October. That post, along with graphic descriptions and pleas for help, quickly went viral locally and beyond. Friends, family, and concerned strangers began sharing the post, widely using the hashtag Justice for Amerie, sometimes spelled Justice for Amerie, on platforms like Facebook, Instagram, and X, which is Twitter. The sheer horror of that story, a 5-year-old brutally attacked by other kids, led to an outpouring of sympathy for the victim and anger towards the situation. Within days, thousands of people had seen or commented on the story, expressing shock and demanding action. This organic social media spread is what prompted local news outlets to investigate and cover the story. They often monitor viral local posts for news leads. And guys, I mean, you can look at the comments. Go to our Facebook page, look at the comments, or our profile page. Justice for Amarie campaign. So Ontavia Kennebrew established a GoFundMe online fundraiser titled Justice for Amarie to raise awareness and funds for her daughter's recovery and legal fight. As of the latest check, the fundraiser has raised tens of thousands of dollars in donations from the public, reflecting significant support. The phrase Justice for Amarie has thus become the rallying cry for those following the case. It encompasses not just a fundraiser, but a broader call that the perpetrators be held accountable and Amarie's suffering not be ignored. Local community activists and child advocates have echoed the slogan. You can see Justice for Amarie signs or hashtags in many social posts. The campaign has served both to keep public pressure on the authorities and to gather resources. So money for medical bills, therapy, legal fees, etc., and also material support like toys and cards to comfort Amarie. And then you get the local media coverage. Once the story broke publicly, Cleveland area media outlets extensively covered it. News 5, which we saw Cleveland, that's WEWS, aired a segment with a direct interview with Ontavia Kennebrew, warning viewers of the graphic nature. We saw that video. Cleveland 19 News also ran a piece with the mother recounting how her daughter was unrecognizable after the attack. WKYC Channel 3 and WJW Fox 8, as well as News 5 follow-up segments, all reported on the case as a major local news story. These outlets balanced telling the horrific fact with sensitivity. Many included warnings about the disturbing content, and they did not show the child's face or name, respecting privacy since she's a minor. They also reached out to Cleveland police for statements which yielded the official confirmation of an investigation, but no detail as noted earlier. The local news story also highlighted the lack of immediate charges, subtly questioning what would be done, which helped fuel public discussion about the legal gap. That's where we're at now. And then you got the national media attention. The shocking nature of this case did not stay confined to Cleveland. National outlets picked it up. People magazine published an article on October 10, 2025, bringing the story to a broader audience. The People article summarized the incident and explicitly noted that Cleveland police were investigating an ongoing case with children under 10 as suspects, and it repeated Kennebrew's key claim about what was done to her daughter. Other national media and websites, including some syndicated feeds and possibly talk shows or podcasts, have discussed the case as emblematic of a disturbing trend or a failing in the system. The national attention has amplified calls for justice and perhaps will put more pressure on local authorities not to let the case quietly disappear. And then you got the community support and vigil. The Cleveland community has rallied around Amarie and her family. On October 10th, as mentioned above, community members organized a toy and donation drive for the little girl. This event at a local recreation center brought dozens of neighbors, activists, and even local officials together in solidarity. Piles of toys, cards, and balloons were collected, a show of love to help Amarie heal, at least emotionally. Local news covered this event as well, noting how it united the community in the face of an awful crime. And neighbors voiced their hope for justice and recovery. One resident said, "I just hope that the mothers get justice and that the little girl is healed mentally and physically." The community gathering served both as a moral support for the family and as public statement that such acts will not be met with silence or apathy. And online, there's been an outpouring of emotion, anger, sadness, confusion, and calls for action. Many commenters are demanding that something be done legally, even given the boys' ages. Others have expressed concern for the young perpetrators as well, questioning what could cause children to do this and urging that these boys receive mental health intervention. There are also significant discussions about parenting, supervision, and how such an event could have been prevented. Some in the community have called for justice for Amarie in the form of legislative change. For example, adjusting laws so that age is not a shield in extreme cases. That's the petition we saw. Meanwhile, misinformation management became an issue. The Cleveland police, by acknowledging the social media posts and clarifying an investigation is underway, was subtly trying to counter any rumors that police had ignored the case. The mother's social media posts themselves have been very detailed. Some individuals initially questioned if the story was real because of its shocking nature, but the swift confirmation by police and media has dispelled those doubts. And then you have the hashtag and petitions, along with the hashtag Justice for Amarie, other hashtags like Prayers for Amarie and Protect Our Children. That's, I think, where the petition is, Protect Our Children, have circulated. There may also be online petitions circulating, for example, on platforms like change.org, demanding justice or legal changes. A quick search in mid-October shows multiple community members discussing starting petitions, though it's not clear if an official one is in place yet, but we did see one. If one exists, it likely urges the prosecutor to find a way to charge the 10-year-old and perhaps to hold the parents accountable, or for lawmakers to change age-related laws. And we read through that petition. It's got a couple areas it wants to create some change in. And then the public emotion, the public response is marked by a mix of deep empathy for the victim and outrage at the notion that her attackers might get away with it. A theme seen in comments: if a 5-year-old can suffer, this 8 or 9-year-old should suffer consequences. There's also a lot of soul searching in the community, wondering how such violence could brew in their neighborhood among children and what signs might have been missed. People are asking if bullying or previous incidents involving these boys were ignored. So beyond just this case, it's sparking conversations about parenting, youth behavior, and community vigilance. And then you have advocacy and support for the family. Numerous individuals and groups have offered help. Victim advocacy groups have reached out to connect Ontavia with resources. Some saw her social post and responded. Some legal professionals offer pro bono assistance or advice after seeing the story. The Rape Crisis Center of Northeast Ohio has likely been involved or on standby, as indicated by Ontavia contacting them. Additionally, some child welfare advocates might use this case to highlight gaps in the system. For example, the story has been discussed in forums like Reddit and Lipstick Alley, which, while not formal media, show the public trying to parse legalities and share information, including the GoFundMe link, which spreads widely in those forums. So that's just an effort to bring more attention to it. Cleveland Division of Police response. The police department's decision to make a statement was itself driven by the public response. They normally do not comment on active child-involved cases, but the aware of a post recently shared statement indicates they needed to assure the community they know about it and are on it. The fact that Cleveland PD addressed it on social media is a testament to how loud the online campaign had become. The Justice for Anne-Marie movement thus far has been effective in raising awareness. It has rallied the community to support the victim and has put a spotlight on the case, likely preventing any chances that it will be quietly swept under the rug. It's a clear example of how in modern times a determined parent can use social media and community organizing to spur action when they feel the system is moving too slowly. Going forward, this public pressure could influence decision makers, prosecutors, judges, and politicians are surely aware that many eyes are on this case and that there's an expectation for some form of justice or reform. Now, I got some key questions here that we're going to want answered. And I want to go ahead and go over some of these questions with you. So let me just get the questions ready. All right, so here are some key questions raised by this case. Given what is known so far, the Anne-Marie case raises numerous important questions that media, the public, and lawmakers are or should be asking. Okay, these include: how could such extreme violence be committed by such young children? What factors in the upbringing or environment of 8 to 10-year-olds might lead them to plan and execute a brutal assault? Were there warning signs in their behavior previously, like bullying, harming animals, prior incidences, that were missed by parents, schools, or authorities? Were the juvenile suspects themselves victims of abuse or trauma? Often when children perpetrate sexual violence, it can be a sign they have been exposed to sexual abuse or extreme violence. Should investigators be looking into the homes and backgrounds of these boys for signs of neglect, abuse, or exposure to pornography or violence? This case might prompt a deeper question. Are there resources to identify and intervene with at-risk youth before they hurt others? What was the supervision at this time of the incident? On the victim side, how did Anne-Marie manage to walk out of the house on notice? I mean, that's a question we want to answer to. We want answers. Was the family member caregiver negligent, or was this just an unfortunate lapse any parent could have? And again, it's not to shift blame, but just how did this happen? Because they could have lured her out. We don't know that. They could have maybe, I don't know, she could have looked out the window and they could have sworn they could have lured her out. So she could have been lured out. That's why it's good to know how she got out. On the perpetrator side, were the boys unsupervised, and if so, for how long and why? Should the caregivers of all the children have been more aware of their kids' whereabouts? Essentially, if there's any accountability for the adults who are supposed to be supervising these young children that day, what immediate steps can be taken to protect the community from potentially violent juveniles? If 2 of the boys cannot be charged, what will ensure they do not reoffend or harm someone else? Will they receive mandatory mental health treatment or supervision of any kind? This question pushes out a policy gap. The community will want to know that these children are being closely monitored or helped rather than simply sent home as if nothing happened. How will the justice system ensure some form of accountability here? Even if 8 and 9-year-olds can't be charged, could there be creative legal approaches? For example, can a court use CHINS, CHINS, child in need of supervision petitions, or other juvenile court mechanisms to mandate intervention? Could the 10-year-old be charged with something that brings the case into the courtroom, even if only he is formally accused? And if so, will the consequences be proportionate to the severity of the act? Should the age laws be revisited? This case asks lawmakers, is the law adequately balancing public safety and child defender capacities? If an 8 or 9-year-old can literally attempt murder and rape, should there be an exception or adjustment in the law to address such a rare case? For instance, some might ask if Ohio should establish a minimum age of 10 or 12 for criminal responsibility, but also a procedure for extreme cases under that age, like a secure treatment placement. Alternatively, should the focus be on preventing kids from ever getting to this point through better social services? Lawmakers might be questioned on whether Ohio's juvenile system has a gap where it comes to handling the most violent behaviors by the under 10 age group. What role do parents play in preventing and responding to juvenile violence? Should the parents of the offenders' children be held accountable in any way, legally or civilly? How can parents be better educated or supported to keep young kids from engaging in such behavior? Conversely, what support do victim parents need from the system? Did Ontavia get enough help from victim services, or did she have to fight alone? This case could prompt questions about how the system supports victims in juvenile cases, which can be quite different from adult cases with less clarity and involvement for victims. How will Amarie be protected and supported long-term? So beyond the immediate medical care, is the system providing for her ongoing mental health care and safety? For example, do victims of juvenile crimes get access to victim compensation funds or trauma counseling programs? If the perpetrators live nearby, what assurances are there that Amarie won't have to encounter them again? Could there be a restraining order or a requirement that they relocate? This is a question for both public agencies and the community. Transparency versus privacy, is the right balance struck? Observers might ask, given the public nature of the outcry, should there be more transparency when a case like this happens? Or is it right that everything goes behind closed doors since once minors are involved? Some might question if the secrecy of juvenile proceedings is hindering community trust. On the other hand, one must ask how to protect the privacy of child victims and child offenders. For instance, Ontavia initially didn't want her daughter's story everywhere, yet went public out of desperation. How do we balance shining a light on a potential injustice with the child's right to eventually heal without constant public reminder? Could civil litigation play a role? If criminal prosecution is limited, one question is whether the victim's family can pursue a civil lawsuit. Could they sue the parents of the boys for negligent supervision or sue for damages for the injury caused by their children? While suing an 8-year-old is not practical, suing the parents, homeowners, insurance, or such might be possible. This question ventures into tort law. It won't put anyone in jail, but could provide resources for the victim. Though money won't fix this, it might fund her care. Lawyers and media might be asking whether a civil suit is on the table and what that could accomplish. And are schools and community organizations taking action? These kids were of school age, the 8 and 9, 10-year-olds, likely in elementary school. Is there an examination of whether their schools had noted any red flag behavior? Are schools in general equipped to address violent tendencies in children? In the aftermath, will there be any educational interventions, like talking to students about personal safety, empathy, or reporting concerns? And the question extends to community centers, churches, etc. They interact with youth. How can they detect and interrupt such issues early? Remember, it does take a community or a tribe to raise a child. So these questions do not have easy answers, but they are exactly the kind of reflection this case forces upon society. Media outlets have already begun asking some of them in interviews, for example, questioning police on what can be done legally, or asking child psychologists to weigh in on how kids so young could do this. Lawmakers in Ohio might soon face these questions directly if public pressure leads to hearings or proposals. And in essence, the case is prompting a look, not just at one incident, but at broader systemic issues: juvenile justice limitations, child mental health, parental responsibility, and victim support. This is where impacts can be made. This is why I wanted to jump on this. The coming weeks and months may bring more clarity as authorities answer some of these questions, like what will be done with the 10-year-old and as journalists continue to investigate the backgrounds and responses involved. All right, so potential court and legal challenges, the cases escalate. So if and when this case escalates to formal court proceedings, there will be several sensitive issues and challenges to navigate, especially given the involvement of child suspects and a child victim. Some potential concerns include juvenile court confidentiality versus public interest, as we mentioned. As noted, any court action involving the suspects will occur in juvenile court behind closed doors. This means the public, including the media and possibly even extended family of the victim, will not be allowed to observe the proceedings. The outcomes might only be vaguely alluded to, if at all, in public record. This could lead to a public perception of a lack of transparency. The community that has rallied for justice for Amarie may be frustrated if they are never told the resolution. This tension between privacy laws to protect minors' identities and the public's desire for justice and information will be a big concern. The court will err on the side of protecting the minors' privacy, possibly sealing everything. The victim's family will likely be informed of the results, but they too may be restricted from sharing details publicly. This could hamper broader conversations about accountability. For instance, if the 10-year-old is ordered to treatment, the public may only hear that measures were taken without specifics, which can feel unsatisfactory, especially related to a case like this. The media handling and reporting. The media will have to be very careful in covering any court developments. They cannot name the juvenile suspects. Media outlets generally follow the rules of not naming minors in such cases, and legally they might be barred from doing so if obtained by from court records. They also still won't name the victim, though her first name is public via the family. Official outlets might continue to say the 5-year-old victim. If there are hearings, reporters might only get secondhand information or statements from the family attorneys. There's also a gag concern. Judges might issue gag orders preventing participants from talking to press, again, to protect confidentiality. And this may cause some frustration, but it's likely to happen because it's a juvenile case. Competency and fair trial for the child suspects. If the case against the 10-year-old moves forward, a key issue will be whether he understands the process. There may need to be competency hearings, as we mentioned, essentially a mini trial where psychologists testify about the child's ability to comprehend the proceedings and assist in his defense. If found incompetent due to age maturity, the case could be paused or dismissed. If found competent, which at 10 is borderline, the defense might still argue the child doesn't fully grasp the consequences of his actions, diminished capacity. Ensuring a fair process for a 10-year-old is tricky. His attorney will have to simplify concepts, and the judge will likely take great care to explain things in a child-friendly language. The court might also consider the child's mental health. For example, does he have any developmental issues, learning disabilities, or trauma that needs addressing? All this could slow down proceedings or complicate them. There's also the moral concern: can a 10-year-old meaningfully waive rights or make legal decisions? Usually, a parent or guardian ad litem would be involved to make decisions in the child's best interest legally. Impact on the young victim in court. If a juvenile case proceeds, what role will Amarie or her testimony play? In juvenile delinquency adjudications, the victim, especially a child victim, typically does not have to testify in open court, like an adult trial, often because the judge can rely on statements and reports. They might avoid subjecting the 5-year-old to cross-examination. Perhaps a forensic interview, a recorded interview by child psychologists specialized in abuse cases, could be used as evidence instead. However, the defense for the juvenile could demand the right to question evidence, though in juvenile court, rules are a bit more relaxed and aimed at truth-finding rather than adversarial battles. The concern is protecting Amarie from further trauma. Facing her attackers or recounting the ordeal again could be extremely traumatic. Courts often try to shield child victims by using tools like closed-circuit testimony or having support persons with them if they must speak. Here, since the trial would be a bench trial, just a judge, the judge might accept written or recorded evidence of her statements to avoid making her relive it in a courtroom. And then the evidentiary challenges. Legally, proving this case has challenges. The suspects are so young that their statements might not be reliable. They could lie, or they might have been coached by parents once this blew up. If none of the boys confess, or if they give inconsistent stories, evidence like DNA or injuries will be the key. But consider, a child's DNA might be found on Amarie if, say, saliva from a bite or skin under nails, but among 3 kids who probably played together, DNA could be hard to attribute to the act specifically. Also, since they're sibling or friends, unsure if they're related to each other, but likely neighborhood friends, their DNA might be in each other's environment normally. The lack of an adult witness, except the ones who saw 3 kids, is an issue. that witness presumably saw them from a distance and maybe intervened after or called 911, but identifying which child did what is complex. Fingerprints on the sticks or objects could tie a particular boy to that part of the assault. The defense could argue it wasn't my child, it was the others. And with all of them under 10, it's possible none has prior record to make one more suspect than the other. So the prosecution in juvenile court might face evidentiary hurdles, especially if trying to pin specific acts. Like, for example, who did the strangling, who did the penetration. They might opt for a general charge that all participated in a felonious assault as a group. The standard of proof in juvenile court is still beyond a reasonable doubt, so they need to meet that. And then for sentencing, if the 10-year-old is adjudicated delinquent, the court then has to decide what to do with him. This will be very sensitive because of his age. Any placement in a juvenile facility could be challenged as potentially harmful to someone so young. But given the severity of the offense, simply putting him on probation at home may be seen as too lenient. The court might try to find a middle ground disposition, perhaps placement in a secure treatment center that is not as punitive as youth prison, but ensures he's not free to roam. The concern is balancing public safety. He did something gravely violent with the fact that he's a child and arguably a product of environment needing rehabilitation. Judges also know that putting a 10-year-old in a juvenile lockup is problematic. Juvenile facilities usually house teens who might harm a young kid, so they need a special arrangement. There's also a concern that any punishment might violate the spirit of juvenile justice if it's too harsh for a child. The defense could argue for leniency due to age. The prosecution and victim's family likely will argue this act deserves a serious response. And the long-term monitoring, another legal aspect, is if a juvenile is found to have committed a sexual offense. Sometimes states have sex offender registration laws. Ohio does have juvenile sex offender registration in certain cases, but typically it's for older minors and usually discretionary. It's highly unlikely a 10-year-old would be forced to register as a sex offender. That would be seen as counterproductive. Instead, the focus would be on treatment. However, the public might worry, what happens when he turns 18? Will anyone know what he did? The answer is likely no. Record sealed. The system might have to reassure that he'll be rehabilitated. If not, that raises a concern about future risk. But legally, once the juvenile system has handled it, assuming they do, there's no mechanism to continue monitoring past the age of jurisdiction except if he reoffends later. And then this is stuff, guys, I'm learning in the process. And privacy laws and the victim's family and the victim's family's voice. Juvenile privacy laws also gag the victim's family to some degree. While Octavia can speak about what happened to her daughter, as she has, if a juvenile case is ongoing, she might be warned not to disclose specific proceeding details. She can continue to advocate generally, but she may find herself constrained. If she disagrees with the outcome, say the boy gets a light disposition, she might not be allowed to detail it publicly. That could be extremely frustrating for her and supporters. It could even lead to someone leaking info anonymously if they feel justice wasn't served. The court will have to manage this carefully. They may invite the family to give a victim impact statement. Where am I? At disposition, but that too is in closed court. Ensuring the victim's rights to be heard, to be informed within the confidential juvenile process will be important. Ohio law does give victims the right to input, even in juvenile cases, but it's all non-public. And the backlash and protest, if the ultimate court outcome is perceived as too lenient, for instance, it effectively nothing happens to the boys, which is possible with the two younger ones, and even the 10-year-old might get only therapy. There could be public backlash, protests, or at least outcry on social media might occur. The justice system typically doesn't bow to public opinion for individual cases, but significant public pressure can sometimes influence policy down the line. In court, though, a judge's job is to apply the juvenile justice standards, not to appease the crowd. This discrepancy could lead to public relations issues. Authorities might then need to explain the outcome in general terms to cool tempers, which is a delicate PR task given confidentiality rules, and then ensuring the safety and rehabilitation of the offenders. Another concern is how the juvenile system will address the clear danger these children pose. The court will likely order psychological evaluations. If any boy is found to have serious mental disturbances, conduct disorder, etc., the worry is whether the system has adequate facilities to treat them at this age. If they are simply returned to the community after some counseling, will they actually be reformed, or could they remain a threat? This is more a child psychology concern, but it plays into legal decisions about placement. The presence of sexual behavior at such a young age often triggers specialized intervention. There are therapists who work on problematic sexual behaviors in youth. Ensuring they get proper treatment is a must, and if their family environment is contributing, to their behavior, perhaps moving them from that environment for a time is necessary. As we mentioned, the juvenile court can mandate these things, but success is not guaranteed. A lingering concern is, what if these boys do something violent again, either as juveniles or later as adults? Legally, whatever happens now may be sealed. So if one reoffends at 18, the prior record might not influence an adult sentence. And in summary, if the case goes into the courts, juvenile system expect a very delicate and possibly contentious process. Privacy laws will keep much of it out of the public eye, potentially causing frustration. Ensuring fairness for a 10-year-old defendant while also delivering justice for a 5-year-old victim is a daunting task for the juvenile court, and it raises broader philosophical issues. Can a child be held responsible in a way an adult is? And if not, how do we protect society and victims in such scenarios? The court's handling will likely be scrutinized, even if from a distance, and it may serve as a test case for how such young offenders are dealt with in Ohio. So, guys, here's my conclusion. The Amory case does more than tell a tragic story. It exposes cracks in how our legal and child protection systems respond when both the victim and the offender are very young. Ohio, like many states, lacks a clear framework for handling serious violence committed by children under 10. The law assumes kids that young cannot form intent, but this leaves families like Amory feeling as though justice, like Amory's feelings. The law assumes kids that young cannot form intent, but this leaves families like Amory's feeling as though justice simply doesn't exist. Beyond accountability, the case raises pressing questions about whether we have the right resources to rehabilitate children who commit violent or sexual offenses. Are there secure treatment options for 8 or 10-year-olds who pose a danger, or are we leaving families and communities vulnerable by sending those children back home with little oversight? It also highlights uncomfortable truths we rarely confront: child-on-child sexual violence, gaps in parental accountability, the absence of coordinated agency responses, and victims who fall through the cracks when no formal charges are filed. Even well-meaning reforms designed to protect juveniles may need to be revisited to ensure exceptions exist for extreme cases. Ultimately, Amory's case demands that we rethink prevention, intervention, and victim care. This isn't about treating children as adults. It's about building a third way: intensive, mandated intervention that protects the public, supports victims, and still recognizes the developmental realities of young offenders. Whether through new legislation, expanded mental health services, or better cross-agency collaboration, this tragedy should serve as a turning point. If nothing else, the lesson is clear. We cannot assume kids can't do this. They can, and in rare, devastating cases, they do. The question now is whether our systems are prepared to respond, and that is going to be the dialogue I'm going to start having going forward. I'm definitely going to start trying to get some guests on and start discussing this, because it's maybe nuance, but it happens. We'll love your thoughts on all this. There's a lot here, but thank you for watching, and see you soon. Stay safe.